On July 15th, 23-year-old Montress Little and 21-year-old Jared Clinton were pulled over by Officer Kyle Feiss from the Des Moines Police Department in Des Moines, Iowa, shortly after leaving a local park. As the officer approached the car, he began questioning them about the vehicle and stated that he noticed the smell of marijuana. Before even checking Mr. Little's identification, Officer Feiss ordered him to step out of the car. Everything that happened next was recorded on the officer's body camera footage.
What's going on, guys?
Not much.
What's up?
How you doing, officer?
Is this your car?
Well, it's a rental right now. My car's in shop.
Okay. Did something break down?
Yes, sir.
Gotcha. You guys just came from over at the park, right?
Yeah, we just hanging out.
That's it?
Well, that's what we doing.
Is this your car?
I just told you my car's in the shop, officer. This is a rental.
Okay. How do you start it?
What do you mean? I just put my foot on the brake and I put it in drive and I drive, officer.
So it's your car, though? Did they give you a fob or something?
It's my car, officer.
Did they give you a key fob or something? Or?
Yes, sir. Officer.
Like, what does it do? Does it?
You see, this should let you know that it's in.
Okay. Do you have any weapons on you or in the car?
No, officer.
Okay, can I be honest with you? It smells like marijuana in the car, and I can see shake on the ground. And your buddy's giving me the idea that maybe he's got a gun. You know what I mean? Like, that's what I think.
How?
I don't know. Just the way. I mean, just the way you're holding yourself, man. Like, that's why we're nervous, man. That's it. I mean, if you're scared because you got a little bit of weed, that'll be one thing.
Officer,
okay.
There's no weed.
Okay.
There's no shake on the floor.
I don't have a gun.
Okay. So there's no shake on the floor.
Officer.
No.
Okay.
It's
All right.
rental.
And you don't have any weapons on you, you said?
Officer, that is correct.
Okay, do you have your ID on you?
Why don't you want to get in trouble with the police?
My brother's been pulled over multiple times for doing that. I live in Des Moines. I go to work. I don't like doing it.
Okay. You don't got no weapons on you?
Officer, no, sir.
Go ahead and step out, Montre.
Actually, I did.
Yep, I just told you why. 3 times. Do you want me to recap again?
Officer, look, my hands is up.
Yep, your hands are up, and now I'm asking you to step out of the car.
I gave you my ID.
You gave me your ID.
Go run it.
Yep, I don't want to. I'm not walking away from this car.
Let's talk about what just happened in that first 2 minutes. Because Officer Feiss packed a lot into very little time. He walks up, asks how to start the car, which sounds casual, but is actually a way of testing whether Mr. Little actually owns or is familiar with the vehicle, then immediately pivots to claiming he can smell marijuana, sees shake on the floor, and suspects Mr. Clinton of carrying a gun. That is 3 serious legal conclusions drawn before he is even asked for identification. Under the Fourth Amendment, as established in Terry v. Offord, decided in 1968, an officer must have specific articulable facts to support reasonable suspicion before detaining a person or making accusations of criminal conduct. Officer Feiss admits his gun suspicion out loud. Just the way you're holding yourself, man. A hunch about posture is not a specific articulable fact. It is a feeling, and feelings are not probable cause.
Officer, can I ask you why?
Yep, because I just told you. Step out of the car. If you don't want to go to jail, I would expect you to please listen. I mean, I told you I'm a cop. Face the car when you step out. Face the car when you step out. Face the car when you step out. Don't flex. Don't flex. I don't know what you're doing, man, but you need to knock that off. Stop pulling on your arms. What's going on, dude? Where are you trying to? What are you doing, dude?
Officer, I'm not doing nothing to you.
Okay. Well, you're making me think something funny's going on, man.
Come on, man.
You're not under arrest. You're just like you're like pulling away like you're gonna do something silly, and I don't want that. What?
Nothing.
What?
I'm not even gonna.
Okay. Well, you're not under arrest, man. We're just trying to figure out what's going on.
Okay, sure.
Okay, so slide over here. I mean, your heart is thumping, dude. Like you're beaten.
Officer, please don't.
Don't what? Have a seat.
Okay.
Have a seat. I think that your buddy has a gun, so I need you to step into the car.
You think my buddy has a gun?
He's acting funny. Step in the car, please.
Officer,
if you don't step in the car, you're going to jail for sure.
Okay, that's
so
fine,
step
officer.
in the car. So step in the car.
Listen.
I'm done listening. I just told you I think that your buddy has a gun. Now knock it off.
Nothing in there. Can you spread your feet just a little bit?
This is the moment when the traffic stop begins to raise serious concerns. Officer Thice told Mr. Little to step out of the vehicle, something officers are generally allowed to do during a legal traffic stop. A Supreme Court ruling from 1977 stated that officers may ask a driver to exit a vehicle after a lawful stop without violating constitutional protections. But the key issue here is whether the stop was lawful in the first place. Based on the footage shown so far, no clear reason for the stop had been explained. If the initial detention was not properly justified, then every action that followed becomes far more questionable. Mr. Little responded by saying, "I gave you my ID. Go run it." That was not a threat or an attempt to resist. It appeared to be a simple question from someone trying to understand why he was being held. The situation then became more tense when the conversation quickly shifted toward possible arrest instead of clarification.
All right, come back and stand with me, okay? You're not going to run from the area.
How old are you, Montre?
March 25th, 1995.
You supposed to be drinking in the park there?
Officer, officer, that's just in there, okay? There was no gun, there was no weapon to harm you, officer. We didn't do anything wrong. We stopped at the stoplight. We pulled over when you pulled over. I did everything you asked me to, officer. You thought there was a weapon. There's no weapon. We wasn't doing anything wrong, officer. I'm not sure why you pulled me over. At your rental, everything is fine. There's no breaking taillight or nothing, officer. I did nothing wrong with you.
Okay. He's gone for the night. You might try calling a cell phone. Copy, thank you.
Mr. Little made an important point during the stop when he calmly said, "I'm not sure why you pulled me over." It was a direct and reasonable question, yet none of the officers clearly explained the reason for the stop. That detail matters because the legality of everything that happened afterward, including being told to exit the vehicle, the frisk, and the vehicle search, depends on whether the stop itself was justified from the start. The Fourth Amendment protects people from unreasonable searches and detentions. In a 1979 Supreme Court decision, the court explained that police actions must be weighed against a person's constitutional rights and whether there was a legitimate reason for the intrusion. In this situation, there was no visible traffic violation, no broken light, and no registration issue shown on camera. Simply leaving a public park is not against the law. Based on the footage available at this point, there appears to be very little evidence supporting the decision to initiate the stop.
That's good, man.
If I take them handcuffs off you, can you dump out that bottle of alcohol for me?
Oh, I could do it anytime, officer.
Is that good?
Yeah, of course it is.
You good? We straight? Okay, so here's the deal. Like, you and I know. I mean, let's start over. Let's roll with each other. Did I make anything up when I said the car smelled like marijuana?
Yeah, a little bit.
Hold on.
Because there was nobody smoking in the car.
Is there marijuana shake on the floor of the car?
Officer, that was cigarette ash, okay? You didn't find no marijuana.
I'm not charging you with marijuana. But here's what. If you want me to be real with you, like, I want you to be real with me for a second. Like, did I make that up? You know what I mean? Did I make it up?
I believe so, officer.
Okay, so you want me to just write you the ticket for the stuff that I had to write you tickets for? If you think that I'm lying, like, then we'll go to court and we'll talk about it then.
Okay.
Or do you want to just be real with me and I'll be real with you?
Wow, officer.
Right?
I would like to pull out my alcoholic reaction to, officer. You didn't find anything. We wasn't doing anything, officer.
Okay. So you're not going to admit that you maybe were around people smoking or something like that?
Officer.
Were you around anybody smoking?
Cigarettes.
That's it.
Officer, there's no weed shake on the floor.
At this stage of the encounter, the officer changes his approach and begins asking questions in a much calmer and more personal tone. The handcuffs are removed, the conversation becomes more relaxed, and the officer encourages Mr. Little to be honest with him. While it may sound casual, this type of questioning is commonly used during investigations to encourage people to make statements against themselves. Courts have previously ruled that officers are allowed to use certain deceptive tactics during questioning. Because of that, many defense attorneys advise people to be careful about what they say during these situations. Mr. Little did not agree with the officer's claims or make any statements connecting himself to marijuana. Instead, he challenged the accusation directly and pointed out that nothing had been found. He also avoided giving answers that could later be used against him. Under the Fifth Amendment, people have the right not to answer questions that may incriminate them. Throughout the interaction, Mr. Little remained careful with his words and chose not to provide the kind of statements investigators often try to obtain during questioning.
Step out. Raise the car. Go ahead and go grab it.
try not to be nervous. And then it won't make us nervous. Okay?
Usually when we see that, with somebody sitting there like that, like there's a gun right where you know what I mean? Like, I'm telling you, like that's what happens.
Okay.
That's the only reason that happened, is because like you were just making it seem like something crazy is going on when it could have just been something little as that, or like a bag or something. Like we jump automatically to what?
Yep, I already know.
Do you have any questions?
No, have a great night.
All right, thank you guys.
After everything that happened during the stop, the unclear reason for the pullover, the marijuana accusation, the claims about a weapon, the vehicle search, the handcuffs, and the extended questioning, the situation ended without any arrest or citation. The only thing officers requested was for a beer to be poured out before the two men were allowed to leave. That outcome raised even more questions about whether the stop was justified from the beginning. Courts have repeatedly ruled that a traffic stop cannot be extended longer than necessary without a valid reason. In this case, no clear explanation for the original stop was ever fully provided on camera. Throughout the encounter, Officer Theis relied heavily on assumptions and personal suspicion rather than clear evidence. He claimed to smell marijuana, but reportedly found none. He suggested one passenger may have had a weapon based on body language alone. Mr. Little was ordered out of the vehicle before his identification was even checked, and the situation quickly escalated into a vehicle search, handcuffing, and further questioning. The Fourth Amendment was designed to protect citizens from unreasonable searches and detentions. Following the incident, Montrez Little and Jared Clinton filed a federal lawsuit, arguing that they were stopped and searched without proper legal justification. In June 2019, the city of Des Moines agreed to settle the case for $75,000. Officer Theis was later removed from patrol duties after an internal review, although he was not terminated. Reports also stated that the city fought to keep parts of that review confidential under Iowa public records exemptions. As for Montrez Little and Jared Clinton, both men remained calm and controlled throughout the entire encounter. Mr. Little provided his identification, followed commands, and continued asking reasonable questions without escalating the situation. Both men also avoided making statements that could be used against them later. Instead of simply forgetting the incident, they chose to challenge it through legal action alongside community